this morning, so you're well familiar with the lights and the timing and everything else, so welcome. Looking forward to it. We only have one case this morning on the docket, and it's 23-20604. Several initials in Jane Doe versus Salesforce Incorporated. So, Ms. Ho, whenever you're ready. Good morning.
Good morning. Good morning, Your Honors. May it please the court. Human trafficking is an unmitigated evil. Two of the criminals who trafficked plaintiffs through ads posted on Backpage have been brought to justice and sentenced to nearly 60 years collectively in prison. But plaintiffs' claims against Salesforce, a market-leading software provider that all agree had nothing to do with the ads used to traffic and thereby harm plaintiffs, are barred by Section 230's plain text and this court's binding precedent for three fundamental reasons. First, though it was a key point of contention below, plaintiffs no longer challenge that Salesforce satisfies Section 230's threshold requirement. It provides interactive computer services, as the district court ultimately and correctly held. Second, text and precedent compel the conclusion that Section 230's second requirement is also satisfied. Plaintiffs persuaded the district court that to invoke Section 230, a provider has to be a publisher. But that reads the word treat right out of the statute. Section 230 bars any claim that treats a provider as the publisher or speaker of another's content. Here, the trafficking ads. That's exactly what plaintiffs seek to do, hold Salesforce liable for the harms inflicted by the ads. Third, precedent forecloses plaintiffs' attempt to reframe their claims in terms of Salesforce's own conduct. Plaintiffs seek damages for horrific harms caused by trafficking. And without the trafficking ads, there would have been no trafficking. So third-party content is the essential component of their claims. Section 230 bars those claims because they require treating Salesforce as the publisher of those ads by imposing liability for the harms those ads inflicted. No ads, no harm, no case against Salesforce, and no reframing can avoid that conclusion and defeat statutory text. Now, I understand that plaintiffs now concede at page 23 of their brief that they aren't challenging the district court's conclusion that Salesforce is a provider of interactive computer services because it's an access software provider that enables computer access by multiple users to a computer server. But walking through why Salesforce is a provider, even though now conceded, I think also helps show why their argument that you have to be a publisher to be treated like one can't be right as a matter of plain statutory text. I think that's the reason, Your Honors, that this point was so fiercely and vigorously contested by plaintiffs below. I think they understand that once you pass the first gateway, that you are an interactive computer, that Salesforce is an interactive computer services provider. As a matter of plain text and precedent, Salesforce also satisfies the second requirement that plaintiffs' claims necessarily treat Salesforce as a publisher, as the publisher of the ads.
Ms. Ho, are you saying that if you satisfy that first prong, that you necessarily satisfy the second in all cases?
No, Your Honor, absolutely not. What I'm saying is that it wouldn't make sense as a matter of the statute to read the first requirement, right? In other words, to read the second requirement to say you have to be a publisher while acknowledging and conceding that you can be an interactive computer service provider, as the text provides and as case after case has held, without being a publisher. Absolutely, Your Honor, you could not be entitled to Section 230 protection under the second prong for any number of reasons. Our position in this case is that as a matter of plain text and binding precedent, I think this is a relatively straightforward application of the text and this court's precedent that is right in the heartland of the conduct that Section 230 immunizes. And I think an important reason why that's true, Your Honor, is that if Congress had wanted Section 230 to apply only to actual publishers, it easily could have said so. Instead, it extended immunity to claims that treat a provider as either the publisher or the speaker, a provision that wouldn't make sense if only publishers were covered.
So in your view, what allegations or claims by the plaintiffs treat Salesforce as a publisher or a speaker?
Yes, and I think the key point here, Your Honor, is that plaintiffs are seeking damages for harms caused by their trafficking. If the ads didn't exist, there would be nothing connecting Salesforce to the trafficking. No ads, no trafficking, no harm, no claim against Salesforce. So plaintiffs' claims seek to hold Salesforce liable for trafficking harms based on the third-party ads. And that's exactly the analysis that this court in MySpace at 419, in Dietz versus Google at 7, in Snap at *1 looked at. It said, look, if the harm that you are seeking damages for, if it originates in the content of another, then the claims necessarily treat you as the publisher, in other words, as the one responsible.
Is that the but-for analysis that's been referred to?
I think it's similar, but I don't think it's exactly like that, Your Honor. I think it's but-for in the sense that it's not a causation analysis, Your Honor. It's looking at, I think what this court said in MySpace at 419, it said, look, if a plaintiff is saying they've been harmed, right, by third-party content, they can go after the author of the content, right? They can go after the criminal traffickers, but they cannot go after, seek damages, seek to hold liable an interactive computer services provider for harms that originate in that content. Here the third-party trafficking ads, Your Honor.
Ms. Ho, your brief relies on MySpace quite a bit. MySpace was decided back in 2008. Section 1595 was not in existence at that time. And to my recollection, MySpace involved common law claims of negligence and the like. Here we have a statute that is attempting to curtail and prevent sex trafficking, a very different situation. Does that change the analysis in that we're looking at a statute that specifically talks about conduct not only in that a provider would be engaging in, but as well as someone that profits from that? Does that change the analysis?
No, it doesn't change. It doesn't change the Section 230 analysis to the extent that what the court first looks at, right, is do you have an interactive computer service provider who plaintiffs' claims treat as the publisher or speaker of the content? You're correct that in a sex trafficking case, the analysis would then go on to consider whether one of the three narrowly crafted exemptions that Congress amended the statute to add apply. In this case, only one of those exemptions is at issue. You would then go through a separate analysis. Do you have a claim brought under Section 1595? And here with respect to plaintiff's Chapter 98 claim, you do not have a claim brought under Section 95. And if you have a claim brought under Section 95, you go on to consider whether the conduct underlying the claim constitutes a violation of Section 1591. This is a relatively straightforward case because plaintiffs have never argued or alleged that Salesforce itself violated Section 1591. So the FOSTA exemption here doesn't apply. But the FOSTA exemption, and I think it's useful to look at, I think, Your Honor, if Congress had done something different, if Congress in response had gone back and amended Section C1 or C2, which is what this court looked at in MySpace, it would be a different story. But Congress tellingly did not do that. Congress left those statutory provisions that this court interpreted in MySpace, the exact same provisions, and it merely added 3 narrow exemptions for sex trafficking claims that, in a case like this one involving sex trafficking, after you do the Section 230 analysis, as the district court did, if Section 230 immunizes the claims, as we submit it does here, you would go on and then apply the FOSTA analysis. And again, our submission in this case is that those requirements are not met either.
Before we leave, and I'm not implying that you're about to leave the 230 analysis, but while we're still on the topic, in your brief you said that you don't just look to the complaint to see whether or not to decide the publisher-speaker analysis. But isn't MySpace and all GG and all the other cases that we're looking at, they were all decided on at the 12B stage, correct?
Yes, that's correct, and I think that's, and thank you for asking that question, because I think that's a hugely important distinction between this case and the GG case in the Seventh Circuit. You're right that the vast majority of courts will resolve Section 230 cases on the pleadings, because it's an immunity from suit, not just liability, that should be decided at the earliest possible juncture.
And doesn't that imply that that's a question of law that's decided on the complaint?
And our submission, yes, and it is also a question of law that's decided at summary judgment. And in this case, unlike in GG, there was discovery into Section 230 and also into the FOSTA exemption as well. And so the district court here in this court has more of a record, and that record refuted several of the propositions that the courts in GG were required, because that case did arise at the pleadings. They were required to credit the allegations in the pleading. At this stage, at summary judgment, the allegations of the complaint fall away, and it is my friend's responsibility to come forward with facts and record evidence to put into issue, I think, Section 230 as well, but particularly the FOSTA exemption. And our position is that they did not do this. So I agree with you, Your Honor, that this case is in a different procedural posture, but it is still a matter of law that the district court decided on summary judgment, and as a matter of interlocutory review, also certified that the questions that this case presents and immunity are questions of law and not of fact.
Why shouldn't the court follow the Seventh Circuit's approach? I did hear you say that it was in a different posture, but what
yes,
was the reason not to apply that analysis?
Yes, and I think that posture is critical. This court does not need to depart from the Seventh Circuit, because that case is easily distinguishable. The Seventh Circuit made very clear in that case that it was crediting the allegations in the pleading there, as it was required to do at the 12B6 motion to dismiss stage, and several of the allegations that the Seventh Circuit relied on this record, as we lay out in our briefing, have now been conclusively disproven, or there's no fact issue concerning those. So GG is no barrier to this court reversing, because it's distinguishable because of the procedural posture that Your Honor and that Judge Morales highlighted. And so for all those reasons, we would ask this court to reverse and render in Salesforce's favor. And I think I reserved 5 minutes.
Okay, Ms. Hope,
Thank
thank
you,
you
Your
very much, and we'll see you back on rebuttal in about 20 minutes. Mr. Harris, welcome. Good morning.
Good morning. May it please the court. The issue before this court is whether plaintiff's claims treat Salesforce as a publisher or speaker of third-party content such that it's entitled to protection under Section 230. Because plaintiff's claims seek to hold Salesforce liable for conduct that has nothing to do with publishing, plaintiff's claims don't implicate the statute. Under Salesforce's reading, Section 230 would apply anytime publishing is involved somewhere in the victim's trafficking. The district court correctly rejected that view and agreed that plaintiff's claims do not treat Salesforce as a publisher of third-party content under any plain reading of the statute. Let me turn first to Doe versus MySpace. This court held that Section 230 protected the defendant that enabled the third-party user to publish the content online. The district court here correctly held that Doe versus MySpace is not applicable because the plaintiffs sought to hold MySpace liable for publishing the communications on its website. The plaintiffs' claims in that case were barred. And this court's later decisions addressed the same type of circumstances as the district court here recognized. But here, plaintiffs' statutory sex trafficking claims don't fault Salesforce for taking any action that falls within the plain meaning of publishing. It's undisputed that Backpage on its website published ads through which plaintiffs were trafficked. And it's undisputed that Salesforce did not have any role in publishing or enabling the publication of that content. Instead, plaintiffs' claims rest on Salesforce's conduct in knowingly benefiting from serving as a longtime business partner for the sex trafficker Backpage. Let's look at plaintiffs' claims. Plaintiffs' claims fault Salesforce for helping Backpage manage its relationships with sex traffickers who are existing customers and market itself to additional sex traffickers to grow its business. The claims also fault Salesforce for creating a cloned copy of Backpage's database so that Backpage could move data to the Netherlands while it was under intense law enforcement scrutiny in the United States. And plaintiffs' claims fault Salesforce for providing continuous, personalized support to assist Backpage in utilizing Salesforce's technology to advance its sex trafficking enterprise. None of these allegations treat Salesforce as a publisher under any plain reading of Section 230. And the district court here correctly held that plaintiffs' pleadings focus on holding Salesforce liable for its own individual actions with respect to allegedly benefiting, facilitating, and furthering Backpage's sex trafficking venture, and that these claims are not claims for publisher or speaker liability.
Is there, under your argument, is there any scenario in which a back office provider like Salesforce would be entitled to Section 230 immunity?
It depends on what that back office provider is doing. And I know Salesforce puts a lot of attention on that phrase that was used, I believe, at one spot in the district court's opinion after it went through the proper analysis of treat as a publisher. But that's really the test, Your Honor, is what the back office provider, if we want to use that term, did. Are the claims made against that person treating it as a publisher? That's really the test and what it comes down to. And where someone might be termed a back office provider, for example, is an internet service provider. There are several cases like that deal with GoDaddy, where GoDaddy provided all the support and work to actually support the website that published the content. And internet service providers are often held to be protected by Section 230 because they're being treated as a publisher. Sometimes the internet service provider actually does screening of content as well.
So under your argument, if Backpage used an Outlook or Gmail subscription to communicate among employees about, hey, how can we get more traffickers to advertise on our site, would Outlook or Gmail be entitled to Section 230 immunity?
I believe it would be, unless it fell within one of the exceptions to it. But if you look simply as whether it's being treated as a speaker or publisher, I believe that when you're posting the email or posting something on an internal bulletin board, you're treating them as a publisher. But that's very different, because remember, the work Salesforce did here had nothing to do with the website that published the content. This is work that Salesforce did to help Backpage market itself. This was marketing work that was done, nothing that was done external facing with the website where these ads were published.
So what do you make of the contention by Salesforce that Salesforce wasn't, quote, used in any way? So in their blue brief at page 12, Salesforce says our stuff wasn't used in any way in connection with the advertisements. What do you make of that?
I think that shows our point. They're not being treated as a publisher. I mean, I embrace that statement, Your Honor.
Well, if plaintiffs' harms derive from the advertisements on Backpage, and Salesforce wasn't used in any way in connection with those advertisements, is there a standing issue? I mean, how are plaintiffs' claims traceable to Salesforce?
That is a question of liability under Section 1595. The district court at the motion to dismiss phase denied the motion to dismiss under Section 1595. So that motion's already been dealt with. That's an issue for trial. That's an issue that would be dealt with at trial. And I think certainly the plaintiffs will hear Salesforce say, we didn't cause, there's a causation issue. That's a trial issue if we ever get there. The issue here is solely whether Salesforce is entitled to a 230 defense so that they can end the case now. We're not here to decide the merits. We're not here to deal with the 1595 issue on the merits. But again, the district court's denied a motion to dismiss on that. So that, Your Honor, is where those issues will be raised.
Mr. Harris, the appellant in this case just argued that this decision as to 230 immunity can be decided at summary judgment as well as at the 12B stage. But at summary judgment, you have the benefit of limited discovery to flesh out the issues beyond the complaint. What if this court decides there's a question of fact there as to whether or not they're being treated as such? Can the court send it back, or would that make it a question for the jury to decide? It seems to me to be a legal question that needs to be decided.
I think it probably is, Your Honor. But if there is a fact issue determined here, then this court should affirm the summary judgment, because remember, this is Salesforce motion for summary judgment saying as a matter of law, it has established its entitlement to a Section 230 defense. The district court denied that motion and found that 230 didn't apply. So if this court finds a fact issue, then the district court properly denied that motion and the case should be sent back. Probably in almost every case, I think it is a legal issue to be determined. It could be a mixed question of law and fact for the court to deal with. I think on this record and where we are now, the district court properly denied the motion because Salesforce is not shown that it's entitled as a matter of law to its defense under 230, because the claims here do not treat it as a speaker or publisher. And I believe Judge Douglas asked about the GG case. GG versus Salesforce is directly on point. This court should follow GG. There, the Seventh Circuit said that plaintiffs' claims don't treat Salesforce as a publisher or speaker and don't depend on Salesforce having published or spoken anything. The court said Salesforce was simply not involved in any publishing, but rather the claims seek to hold Salesforce accountable for conduct like supporting Backpage and expanding Backpage's business. And the court recognized the distinction between claims that seek to hold Salesforce liable for its own acts or practices and claims that seek to hold it liable for publishing content created by another. And Judge Boyle in the Northern District of Texas in the SMA case also followed Salesforce, GG versus Salesforce, just like Judge Hainan did, found that it was applicable and found that Doe versus MySpace was not controlling here.
So in your view, can this court adopt the Seventh Circuit's reasoning in that GG case without running afoul of our own precedent?
Absolutely, Your Honor.
And what do you, I'll let you finish that, but what do you make of your friend on the other side's argument that since the posture of the cases are different, that case is not applicable?
Let me address the first question. Can you apply, can you follow GG and still stay within Doe versus MySpace? Yes, because Doe versus MySpace is a focus on the publication, and the language there is whether 230 protected the defendant that enabled the third-party user to publish the content online. What Salesforce did here was not enabling the publication, it was building the sex trafficking business. Again, it had nothing to do with the content, it had nothing to do with the Backpage website, it had nothing to do with publishing, nothing to do with editing that content. As the court found in GG, it's simply a different allegation. It's looking at their own conduct, and that is not controlled by Doe versus MySpace, as Judge Hainan found, as Judge Boyle found. So I think those are consistent. I don't think it makes a difference here that GG was decided on a motion to dismiss. If you look at what Judge Hainan actually cited in the 230 analysis here, it really was almost everything he cited was to the pleading, because to decide the 230 issue, you have to look at what the nature of the claims are. And to look at the nature of the claims, you need to go back to the pleading. Salesforce has wanted to argue that there are fact issues and there are things that conclusively plaintiffs have not established, and I'll talk about some of those. The main one they focus on is whether Salesforce customized its software for Backpage. First, I'll point out that has nothing to do with whether Salesforce is being treated as a speaker or publisher, but there in fact is evidence that that was done. We hear a lot about off-the-shelf products copying Backpage's entire database with the metadata so it could be moved to the Netherlands. It's certainly not an off-the-shelf product. We believe we have established that, but there's at least a fact issue. Some of the other points, they say they did nothing to expand the trafficking operations. I've addressed what those claims are. They say they provided standard support services. The evidence shows, while that was the contract, that Salesforce, in fact, went very far beyond that, and in the language of its representatives, provided service that was not typical and not common. There's plenty of evidence in the record that supports this, but this doesn't matter, because these don't go to the test of whether Salesforce is being treated as a speaker or publisher, because again, in Doe versus MySpace, this court looked at the publication. And that's a big part of where I think that the difference in the two parties here are. Salesforce sets up a test that I think is not the right test. In their reply brief, and they say this several times in the brief, the test for whether a plaintiff's claims treats the provider as the publisher or speaker is whether the plaintiff seeks to hold the provider liable for the harms caused by the content. Where's that language in Section 230? That is an atextual analysis. The fact that a plaintiff's harm is somehow connected to the content doesn't trigger 230. The harm has to result from the defendant's publication, very important word, publication of the content. Under Salesforce's test, immunity would be granted just because the third-party content was involved in the injury, no matter what Salesforce's conduct actually was. That is atextual from whether they're being treated as a publisher, and would immunize conduct that had nothing to do with publishing. And I believe, Judge Douglas, you also asked about but-for causation. Is this but-for cause? The court in GG looked at this issue and said it acknowledged that Backpage was a publisher, but the fact that publishing was involved somewhere in the trafficking does not mean that Salesforce can use Section 230 to shield itself from liability for having participated in Backpage's venture. Importantly, the court said, publishing activity was a but-for cause of just about everything Backpage was involved in. It was an online marketplace. Without publishing user content, Backpage would not have existed. And the court rejected that argument. That is on page 567 of the GG opinion. So a but-for analysis simply is not the right test. That's looking at harm And the issue from this court's decision, Doe versus MySpace, focuses on the publication of the content. And for the reasons I've stated, there is no connection to the publication here. Because nothing in plaintiff's claims treats Salesforce as a publisher or speaker, Section 230 doesn't apply, and this court should affirm the district court's order denying Salesforce's motion for summary judgment. Because I have a few minutes left, let me briefly address the second issue under FOSTA. This issue only becomes relevant if the court finds that 230 applies here. If this court determines that it can address the FOSTA issue even though the district court never reached it, FOSTA expressly preserves plaintiff's claims from the scope of Section 230. The parties dispute the meaning of the phrase, the conduct underlying the claim constitutes a violation of Section 1591. In a beneficiary liability claim like we have here, the conduct underlying the claim refers to the criminal conduct of the venture in which the civil defendant is participating. But Salesforce's argument is that the conduct underlying the claim refers only to the conduct of the defendant in the civil action, so that the plaintiff now has to show that the civil defendant's actions actually amount to criminal conduct under Section 1591. The FOSTA amendments simply didn't change beneficiary liability claims under Section 1595 to now require that the civil defendant itself has to commit a criminal violation of Section 1591. It's inconsistent with the statute to conclude that Congress intended to supplant civil beneficiary liability under Section 1595 with these criminal standards from Section 1591. Importantly, that interpretation would remove the should have known standard in Section 1595 and effectively eliminate civil beneficiary liability. It would be making a major change to the statute. Salesforce's interpretation would limit Section 1595 claims to claims brought against criminal perpetrators under Section 1591, which would rewrite the text of Section 1595. Under the proper interpretation, FOSTA preserves Section 1595 claims like the civil beneficiary claim here, where the defendant participates in a venture that violates Section 1591. For this additional reason, the court should affirm the district court's order and remand.
Mr. Harris, thank you very much. We appreciate it.
Thank you, Your Honor.
Ms. Ho, you're back for 5 minutes. As you're walking out, let me just ask you, help me to reconcile your contention that the Salesforce software was not used in any way in connection with the ads. Reconcile that with a contention that Salesforce is being treated as a publisher or speaker of the ads.
Yes, no good deed goes unpunished, right, Judge Willett? I think the best way to answer a question is to really drill down into this court's precedent, because I think there are direct quotations from this court's binding precedent that answer that question. And let me start with this court's most recent opinion in the Snap Inc. case. Quoting MySpace, the court reiterated that, quote, parties complaining that they were harmed by a website's publication of user-generated content. All right, so that's right there. You're complaining harm by user-generated content. That's because by its plain text, Section 230 creates federal immunity to any cause of action that would make internet service computer providers liable for information originating with a third party. And this court said much the same thing in Dietz versus Google when it said, by its plain text. Yes, Your Honor.
On the Snap case?
Yes.
What were the claims in that case?
Yes, so the claims in the Snap case were state law claims, negligent undertaking, negligent design, gross negligence.
1595?
No 1595, but again, Your Honor, that's a separate analysis from Section 230.
True, but those are the plaintiff's claims.
Yes, they are those claims, but the district court did not reach that in its Section 230 opinion. It ruled against us on Section 230, which we think was an error. And it did not go on to reach I think perhaps there's some confusion here, because when we talk about 1595, that is both a cause of action, right, that the plaintiffs are bringing, but it is also
Part of 230.
part of 230. It is an exemption, right? There's 230, and then there's the exemption. It has to be a claim brought under 1595, and where the defendant is, the conduct underlying it violates 1591. So I think that's where some of the confusion. But my point is right. And I think, Judge Willett, you asked exactly the right question that shows our point when you said, well, under my friend's theory, wouldn't that mean that a back office provider of software could never be entitled to Section 230 protection? And I think the answer to that question, under my friend's theory, can only be yes, which is why we know it has to be wrong that you have to be a publisher to be treated as one. And I heard my friend on the other side talk about publishing activities. That's not in the statute. Talked about publication. That's not in the statute. What the statute says is shall not be treated as the publisher or speaker of content provided by another. This court, in MySpace, in Snap, in Dietz versus Google, has said what does it mean to treat a provider as a publisher? It means to attempt to hold them liable for harm that originates in the content provided by another. And here, that is the ads. And no matter how my good friend on the other side tries to frame it, there is no denying that the claims in this case, both of them, depend on the trafficking ads and seek to hold Salesforce liable for harm caused by that content. And they can't paper over that reality by referring to Salesforce's own conduct, because plaintiffs agree that Salesforce had no role in creating those ads, which is one way that you lose Section 230 immunity, right? Is if you are a content creator, right? You lose immunity in that circumstance. So under this court's binding precedent and plain text of 230, the claims are barred because they require treating Salesforce as the publisher or speaker of the third-party ads that harmed the plaintiff. And here, plaintiffs concede that Salesforce is an interactive computer service provider, that didn't contribute to the content of the third-party trafficking ads, and that it didn't violate Section 1591. So their claims are barred by Section 230. There is no doubt that the plaintiffs in this case suffered unspeakable harms, but the only connection between those harms and their claims against Salesforce is the ads. No ads, no case against Salesforce. Because Section 230 applies, we respectfully ask this court to reverse and render judgment for Salesforce.
Okay, Ms.
Thank you,
Ho.
Your Honors.
Thank you very much. The court appreciates the characteristically excellent advocacy on both sides. It's an important case, consequential, obviously, and you've helped sharpen and refine our thinking about it, so we're grateful. And we'll stand in recess. The case is submitted. We'll stand in recess until 10 a.m. Is that right? Tomorrow morning. All right, thank you.